The Supreme Court just issued a decision in a case over birthright citizenship that could have a huge effect on all pro-gun cases moving forward. Today we're going to talk about that case, Trump v. CASA, and lay out how this decision affects the legal landscape of Second Amendment challenges. I'm Phil, and you're watching Law and Ammo. So how does a case about birthright citizenship affect gun rights? For starters, while the case itself is about birthright citizenship, the Supreme Court decision mostly deals with nationwide or universal injunctions by lower courts. SCOTUS says exactly that in their decision to take up the case, writing, "The issue raised by these applications, whether Congress has granted federal courts authority to universally enjoin the enforcement of an executive order, plainly warrants this court's review." Clearly, the court was less concerned about the birthright citizenship issue as it was with the issue of these universal or nationwide injunctions. And if the term universal injunction sounds familiar, that's because they've been in the news lately, particularly as it relates to the flurry of executive orders that have been issued from the Trump administration. When blue states or liberal activists take issue with an executive order or policy, they'll shop around for a friendly court to sue there. Typically, a Biden, Obama, or Clinton-appointed judge will then be more than happy to halt whatever the executive branch is doing. But how does that apply to pro-gun lawsuits? It's a bit more complicated. During the Biden-Harris administration, Gun Owners of America brought lawsuits against every single anti-gun executive action that they issued. In fact, in the case of Biden's engaged in the business rule, GOA halted the enforcement of that provision nearly immediately after it went into effect. But in each of our cases, including the challenge to the engaged in the business rule, our judges only granted partial injunctions affecting GOA members and other plaintiffs in the suit, including members of VCDL, TFA, and residents of certain states. Of course, we argued with each judge to expand those rulings to all gun owners, not just members of our organization and other plaintiffs. But unfortunately, judges in each case refused to do so. You see, anti-gun, living constitutionalist, partisan, Democrat-appointed judges have no problem abusing their authority to issue nationwide injunctions for left-leaning causes. Meanwhile, conservative, pro-gun, originalist judges who are more likely to rule favorably on the Second Amendment are wary of abusing their limited power as judges granted by the Constitution and the Federal Judiciary Act of 1789. That's why judges willing to help GOA block the Biden administration gun control still weren't willing to give nationwide injunctions. It wasn't that GOA didn't ask. It's that constitutionally minded judges have other constitutional principles that they respect, and this is one of them. So it's no surprise to see the conservative-leaning Supreme Court take up that principle here. Gun owners and the Second Amendment never really got nationwide injunctions before. So this CASA case isn't that big a loss. Really, it just hurts our opponents. But keep in mind, gun owners can't expect to be covered by a nationwide injunction against gun control again, even during another future hostile administration. It's possible that a court could enjoin the enforcement of gun control against gun owners as a class, but the safest bet is to be a member of an organization suing to defend its members like we do at GOA. So this SCOTUS decision in Trump v. CASA really highlights the importance of becoming a member of GOA and keeping it active, so that you as a member can benefit from these lawsuits. But let's take a few steps back and talk about the case itself and figure out what the Supreme Court is really saying. Trump v. CASA centers around President Trump's executive order protecting the meaning and value of American citizenship, which in effect puts an end to the practice of birthright citizenship. For those who don't know, birthright citizenship is the concept that anyone born in the United States is entitled to U.S. citizenship, or at least that's how it's been interpreted for years. The 14th Amendment controls birthright citizenship, which reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." In recent years, this has been interpreted to say that anyone who is born here gets citizenship. But that doesn't explain the original intent of the clause and subject to the jurisdiction. During the Reconstruction era, when this was all proposed by the Lincoln administration, the original public meaning was understood as more of a loyalty oath. What country's jurisdiction do you submit to? The United States or a foreign government? So yes, the children of U.S. citizens and even permanent residents qualify here, but there are key exceptions recognized by the past Supreme Courts. First, foreign invaders would not have the right to birthright citizenship, and that may be the current situation with the border crisis. Again, the children of diplomats are also not given citizenship. Even Native Americans didn't get citizenship under the 14th Amendment until the Indian Citizenship Act of 1924. So President Trump signed an executive order to clarify that the children of illegal aliens unlawfully present, such as children of MS-13 gang members occupying our streets, are not given U.S. citizenship. Of course, this executive order was met with lawsuits from blue states and immigrant rights groups who sued and urged the justices to keep birthright citizenship in place. And while the Supreme Court took the case, like I mentioned earlier, they took the case on the injunction issue and largely sidestepped the birthright citizenship issue. In a 6-3 decision, SCOTUS ruled that universal injunctions were no more. Justice Amy Coney Barrett authored the majority's opinion, saying, universal injunctions likely exceed the equitable authority that Congress has given to federal courts. So universal injunctions are out. What now? It seems that the Supreme Court made a blatant distinction between universal injunctions and class action lawsuits, writing, a judgment in a class action, favorable or not, binds the whole class. So if the defendant wins, it is protected from future suits. But because an adverse ruling on a request for universal relief lacks this preclusive effect, plaintiffs can continue to file in different forums until they find a court willing to award such relief. Basically, what SCOTUS is saying is that they're sick of the court shopping. And we've seen this before, where anti-gun groups will choose friendly anti-gun courts, like those in Massachusetts, to sue large gun makers with untested legal theories and tort claims. But you're asking, why is this all important? Well, because a class action suit could cover all members of a class. Or for instance, if GOA sues and wins, the decision could cover all of our members. This is what happened with our members with pistol braces, frames and receivers, and engaged in the business. This is extremely important as this decision has limited the reach of future lawsuits. And we've just filed one of our biggest lawsuits against the National Firearms Act, the One Big Beautiful Lawsuit. So if you're not already a GOA member, you may want to consider becoming a member so that our victories in our lawsuits can become your victories too. I'm Phil with Law and Ammo. Thanks for watching.